Good evening, everyone. I welcome you all on behalf of IPNet North. I would request Mr. Parag Singhal for his welcome address.
Thank you, Tina. Friends, IPNet webinar on real estate claims and fraudulent transaction in IBC verification challenges and legal insights. I welcome you all on behalf of IPNet in today's webinar. We are incredibly fortunate to have a distinguished panel of guests and speakers who will help make this session both insightful and thought-provoking. Friends, as you all know, today we have two speakers on the topic, aptly divided among them. I would like to extend a warm welcome to both the speakers, IP Mr. Narendra Kumar Sharma and IP Ms. Pooja Bahari. Your presence today truly elevates this event, and we are eager to learn from your vast experience and insights. A heartfelt thanks goes to Shri Ashish Makija, President of IPNet, whose leadership and vision continue to propel this platform forward. IPNet has quickly evolved into cornerstone for insolvency professionals across India. It has become much more than a network. It is a vibrant community where professionals in fact come together to exchange knowledge, tackle challenges, and grow in their careers. Here at IPNet, we are committed to meeting the critical needs of IPs, including continuous learning to expand our expertise, timely solution on matters related to IBC, and powerful forum to invoice concern and find practical and actionable solutions. In response to these needs, IPNet offers several standout features. Specialized study groups that engage in ongoing knowledge sharing, webinars and discussions as we are here today on the latest industry developments, and a dedicated member portal providing easy access to resources that address all our professional needs in one place. So I request all the members who are present here to please visit at least once on the membership portal and take benefit out of it. For those of you who are already part of IPNet, I thank you for your continued support. For everyone and anyone who has not yet joined, I encourage them to become a member of this dynamic community. The membership link is available in the chat, and we look forward to having you with us as members of IPNet. Once again, I thank you all for being here and contributing to what promises to be an enriching and rewarding session. Thank you.
Thank you, sir. Now I request IP Namrata to play IPNet video.
In the fast-evolving world of insolvency and bankruptcy, professionals need more than just knowledge. They need a strong network, continuous support, and a unified voice. As the challenges of the insolvency profession grow, so does the need for a platform where professionals can come together, share their experiences, and find collective solutions. That's why IPNet was formed. Promoted by Transition, IPNet is more than just a network. It's a mission to unite insolvency professionals across India, empowering them with the tools, knowledge, strong leadership, and community support they need to excel. Our purpose is simple: to create a cohesive community of insolvency professionals that stands strong together, advocates for their interests, and drives excellence in every aspect of the profession. At IPNet, we believe in continuous learning and collaboration. Our activities are designed to ensure that every member stays ahead in their field, from specialized study groups that dive deep into critical topics like CIRP, compliances, and many more, to webinars and workshops that bring the latest insights right to your screen. IPNet is your gateway to professional growth. Backed by Transition, a leader in insolvency training and resources, IPNet is committed to promoting the interests of insolvency professionals. Our goal is to ensure that every IP, no matter where they are, has access to the best resources, strong leadership, and a network that truly understands their needs. Join us in this mission to build a stronger, smarter, and more connected community of insolvency professionals. Together, we can overcome challenges, shape the future of the profession, and make a lasting impact. IPNet, National Network for Insolvency Professionals in India.
Just showing the website video as well.
Thank you, Namrata. Now I would request Mr. Sandeep Chitkara to introduce our guest speaker, Mr. Narendra Kumar Sharma.
Good evening, friends. Thank you, Tina. I'm pleased to welcome one of the speakers for the day, Mr. Narendra Kumar Sharma. Mr. Sharma is a qualified FTS. So he qualified in the year 1985 and has been handling various company law matters, accounts and finance, including FERA, BIFER, DRT, and other corporate laws in various public limited companies. He left the job during the year 2003 and started his own practice as a company secretary in the field of corporate laws, industrial policy, and he has been advising corporate houses like Apollo Tyres, SP InfoCity, SpiceJet, Rolta India, and many others. He became insolvency professional in the year 2017 itself, and since then he is practicing as IP only. He has been successfully handling 4 real estate matters, one of which is Indrapuram Habitat Center Private Limited, and which is considered to be one of the most complex real estate matter. Moreover, he's handling matters like Paris Infrastructure Private Limited, Saha Infratech Private Limited Noida, Anand Info H Private Limited, and last one is Space Towers Private Limited. Besides, so he's also handling matters related to, he's also handled matters related to steel industry, like Shamadyog and Vallabh Steel West Private Limited. So this is all about Mr. Narendra Kumar Sharma. So I wish him all the best for this very keynote address by him. Over to you, Mr. Narendra Kumar Sharma.
Thank you very much, Mr. Chitkara. Good evening, everyone. Now the subject given to me is real estate claims. You know, claims form part of one of the important factor in overall IBC resolution of distress asset. And claims basically part from a liability side of the balance sheet. And the beauty of this process is the liability side is verified by the IRP or RP, whereas asset side is valued by the another professional, a registered valuer. And then based on the both these things, once you just a minute, once the claims are verified and valuation report is available, then we proceed further for drafting of the EOI, for inviting Form G, and drafting the RFRP, and then finally inviting the resolution plan. But before that, before I share my experience with the real estate claims, I would like to appraise all about the relevant statutory provisions in the IBC as well as subordinate legislation like regulations. The role of IRP under Section 17 of IBC, he assumed the full control over the affairs of the corporate debtor while CIRP is underway. However, he has the primary responsibility to preserve the value of the company's assets and facilitate a resolution plan. Then under Section 18B of IBC, IRP has a duty to receive and collate all claims submitted by the creditors. And IRP has a limited scope and power of verifying and accepting the claims. In this regard, Regulation 8A, 10, 12, 13, and 14 of IBBI CARP regulation are most important. Out of which I feel Regulation 8A is one of the important regulation, which is primary basically documents available for verification of the claim. But among that, the one of the important factor is 8, capital A, B, and then 4. Such other document evidencing existence of debt. It means it is directly related to the financial debt. For that, we need to refer Section 5.8 of the IBC, because unless he's a financial creditor, he cannot we cannot consider his claim. Then substantiation of claim, Regulation 10. Regulation 12 about a submission of proof of the claims. Now, all the financial creditors, they are supposed to submit proof along with the claims, like their BBA, allotment letter, payment receipt, and finally, the proof of actual disbursement of funds to the corporate debtor. Then under Regulation 13, IRP or RP will verify all the claims. Now, for verification of claims in a real estate matter, we must understand that at the when the CIRP is commenced, the balance sheet is not audited in 100% cases. Maybe for the last 3-4 years. And for verification of the claims, balance sheet and the books of accounts, CRM data, they are the one of the important document for claim verification, which are generally not available with the IRP. Now, what the IRP will do? Reason being, he has been given just a time of 7 days from the date of last date for submission of claims. In real estate matter, there are a large number of claims, and verifying all the claims within the period of 7 days is practically not possible. So IRP, what he will do just a data entry of the claim received, and he will enter the claim based on the claim claimed by the various claimant and the documents available with him attached by the financial creditors. This is one of the big problem for verification of the claim. Reason being, he has no other document available with him to verify the claim. So he will first, the IRP, what he will do, he will prepare a list of all the claims submitted and provisionally approve all the claims. But he is categorically mentioning there that all these claims are provisionally approved. These provisionally approved claim will become a source of litigation in future. And for that, I'll come at a later stage how this becomes a source of litigation. Another important factor in claim verification is resolution professional has no adjudication power. When we speak or say adjudicating power, means he has no power to reject the claim. He has to accept the claim, or he can simply say, okay, I cannot admit the claim due to the following reasons. That is only the IRP or RP has the power. But he cannot directly say, okay, I reject your claim, because that comes under jurisdiction of as a adjudicating power. Now, coming to practical aspect of claim verification. After assuming that, preparing the list of claims, filing the same with NCLT, and constitution of the COC, first COC meeting is convened based on all these documents. Now, either he is confirmed as a RP or he is replaced with another resolution professional. Now, the resolution professional, first of all he will do, he will get the balance sheet audited, and that may take a substantial time, because it is not easy. Even he may not be having the opening trial balance for the whatever, maybe 3-4 years back, but that will consume his lot of time. Meanwhile, the valuation is done, and then when he starts the claim verification, number of problems which come his way. There is a possibility that the financial creditor have made the payment to the promoters by way of cash, and in some cases payment might have been given to promoter's personal account. Now, what is happening? The promoter will give him all the document and allot him the asset space of the corporate debtor. But while collating, if there may be, because if he has made the payment by way of cash, there will not be entry in the books of accounts. Now the regulation 8A will come into play, and basically, as I said, the last one, Roman 4, that will play its biggest role. He may be having a BBA, he may be having or allotment letter, receipt of payment also, but without any details. So based on that, the RP may reject or say, okay, I cannot admit your claim due to the reason that you have not become a financial creditor of the corporate debtor. The moment you do it, you are inviting a litigation for the corporate debtor. Secondly, the same thing may happen when the RP will notice that the payment has not been received in the in the bank account of the corporate debtor, and the payment has been given to the personal bank account of the promoters, whereas he is having all the document as all other allottees, those who have made payment to the corporate debtor. So there is no other option except to not to accept that claim also. So there are other number of cases where RP cannot accept the claim, and but one thing is very important. RP is supposed to intimate the reason for not accepting the claims. Otherwise, if you do not convey properly to the claimant, it means you are inviting litigation, unnecessary litigation on that account. So we are supposed to communicate to the claimant properly that, look, I cannot accept, I'm not in a position to accept your claim due to the following reasons. Now, there is another situation in verification of the claims when you come across that whether this is a related party or not. We have to apply the principle given under section regulation 5, section 5, subsection 24, and we have to put all the clauses of that section for a test whether it is a related party or not. Because in case he's a related party, then he's covered under regulation 21, subsection 2. His claim can be approved, but he will not be having any right to participate, right to vote in the COC. Again, that can be one of the source for litigation. There can be another case before claim before the resolution professional where that is supported by the assignment deeds. Means the original allottee has transferred his allotment right to a third person. Now, no CRM data is available, no balance sheet is available, no trial balance is available. First, RP is supposed to verify the credential of the original allottee. Then only he can come to the assignee. So that will be another problem, another challenge to be faced by the resolution professional. So I have faced all such problems, and I'll request if anyone else have any question, they can ask me and I will clarify that. So this is all about the claims and real estate matters. So Tina?
Yes, sir.
May I raise one question?
Yes.
How I had booked his flat in society.
Your voice is cracking.
I think there is some disturbance in your voice, sir. Yes, you may repeat your question.
So you are not audible. You are not audible.
He is not audible, so can you hold for some time, sir? You can ask question later on, please. Your audibility is not good. Okay, thank you. Who is there? Yes.
Thank you. See, I am Kameshwara, practicing cost accountant and registered valuer, including an IP here from Hyderabad. Okay. Can I proceed?
Yes, please.
Yeah, in the present case, as per the illustration given by Sharmaji, that every real estate case, all these claims will be rejected because there is always cash payment, which is not accounted in the books of account. Because more than 25-30% is paid either in cash advance or subsequent hot payment also. What shall we do in that case?
I could not understand the question properly.
Sir, I
Real
understood.
estate.
Am I audible,
Yes.
sir? He
Yes,
was
yes, you
saying
are.
most of the payments are made in cash,
Yes.
30%, 40%, or 100% payment.
Yes.
Those payments are
Yes.
not reflected in the books of corporate data.
That's right.
Secondly, such books, matlab, this is in addition to what he asked, such books may be
Yes.
in Tally, and Tally are
Yes.
prone to changes,
Yeah.
See,
or
the
in any other
solution is,
mode.
I
Yes,
have understood now.
yes,
Now
thank you.
you have to refer back this problem to the BBA. Now, if I'll just give an example. If the BBA amount says 100 rupees is receivable, total allotment is 100 rupees. 40 rupees in cash, they are paid in cash, and 60 rupees by way of check. Now, if the agreement BBA is for 60 rupees, absolutely no problem. If the BBA says 100 rupees and they have paid 60 rupees, then in the books, as per the books of accounts and BBA, 40 rupees is receivable from that financial creditor.
What is this BBA, sir?
You can say allotment letter, builder buyer agreement, I will say.
Yeah.
We have to go strictly as per the BBA, amount mentioned in the BBA. I hope I'm clear on that.
Sir, can you repeat
No,
it once again?
one second. In the
Suppose
BBA,
60%. Yes, please, sir.
RP, while collating and verifying the claims, has to see the BBA or let me say allotment letter. If the allotment letter is saying the particular space is allotted at rupees 100, then we have to see how much amount has been received. As I said earlier, if he has paid 40 rupees in cash, 60 rupees in by way of check, then 40 rupees is receivable as per the books of the corporate debtor.
So that means the amount of cash which is paid by the home buyer is not to be taken into account.
It is not to be taken into account. Yes. You go through the clauses of the allotment letter of BBA. It is clearly mentioned that all the payments towards allotment of this space has to be made in the bank account of the company. The allottees, they are not reading this clause carefully, because that is the basis for claim verification.
Sir, if by any chance receipt is available with the buyer for cash, then it has to be considered.
Okay, you correlate that receipt with the receipt of rupees 60. You won't find any detail. You will find that receipt of rupees 40 on a letterhead. You even don't know who has signed that receipt. There will be no detail whatsoever on that receipt.
Right, sir. Thank you.
Yes, please.
In each and every case, I have seen that problem, and there is no solution for that. That is one of the source of litigation. I think the buyer is beware that applicable here to read the clauses of the BBA or allotment letter.
Sir, may I mention something? Like before 2015, cash was allowed. Even some sale deeds were done in cash.
Yes.
So will your stand change in case of sale deed if the entire amount is paid in cash?
No,
And
not
sale
at
deed
all.
acknowledges that.
Not at all. Is the money reflecting in the books of accounts of the CD? I have come up, let me tell you, Spotted. I have come across a situation where sale deed was executed, detail of checks was given, but the checks were never given to the corporate debtor. And I have issued a demand notice for that. The party has gone to NCLT, and NCLT simply asked one question. Did you hand over these checks to the corporate debtor? And has the check been encashed? They said no. Then make the payment. It is so simple.
What about cash?
All this conveyance deed or sale deed, in the absence of consideration, they are a void transaction. This is a simple rule in the Transfer of Property Act.
But sale deed mentions cash, an acknowledgement of cash. How can RP verify that? Because books of Tally are always prone to changes.
When it is prima facie, it is written that it is in the cash, then the cash should be handed over or deposited in the bank account of the company by the corporate debtor, or he should have taken that money in the cash cash in hand in the books of accounts. If he has pocketed that cash, so the money has consideration has not come to the books account of company.
And
So
suppose it is
that is a transaction without consideration.
So if suppose that is there in the cash in hand account of the
Yes.
books of account, will it
Yes.
be valid then in that case?
Yes, sir. See, we have to refer to the books of accounts. Books of accounts means cash in hand as well as or the amount has been deposited in the bank account of the company.
The entry
So
journal
now
entry
it is
should,
reflecting.
the entry should clearly mention that it is cash received.
Yes.
The ledger entry should be clear in that case, whether it is cash or check, whatever.
Yes. See,
Right.
whether he can accept, you can accept that much amount by way of cash or not, that is entirely different issue. But for me, for collating the claim, the amount should be reflected in the books of the company.
Thank you, sir.
I think two more people are there in line. Mr.
Yes.
Partha Kamal was the first person, so we'll move sequentially. Mr. Partha?
Yeah, I'm audible. Hello.
Yes, very much audible.
So
Please
my
proceed.
question is after the commencement of CRP, whether
Yes.
this assignment of claim can be possible? Can
Yes.
the allotee assign his claim after the commencement of CRP? If yes, what document he should produce to RP?
See, assignment of debt. It is assignment of debt. It is possible at any stage of
Plainly, I mean,
CIRP.
plainly, it is sale of his own flat. They
See,
find some buyer to sell the
the transaction allowed as per IBC is assignment of the debt.
Yes.
No doubt. The underlying security is always the space. But keep in mind that allotee has no right to transfer the property because he cannot pass a better title to whatever he's having. He's just having a allotee right in that property.
Okay.
You can transfer the property only when the conveyance deed is executed in your favor.
No, but
Now
sir,
if the
possession is given, if possession is given, then he can transfer his property, isn't it?
See, it is immaterial whether you have the possession or not. Even if on the possession, you have no right to transfer that property.
Okay.
You get right to transfer only once you become the title holder of that property.
So what sort of assignment can be done?
Or you can only transfer the allottee's rights.
Okay.
Not the property.
I mean, do you mean to say that, I mean, if I got the possession,
yes,
even the registration is done for my flat,
yes,
but the corporate debtor gone to CIRP, it is
yes,
still the property of the corporate debtor, not mine.
No, we have to look from the perspective of the BBA. The corporate debtor discharged his obligation the moment he hand over the possession to the allottee. Now the only situation left remaining is execution of the conveyance deed or sale deed.
Okay.
You have the you have the possession with you, but you do not have the title of that property with you.
Okay.
Now, I think that as per the latest IBBI guidelines, even they said that RP has a right to hand over the possession with the 66% approval of the COC. But still, he will have a say in the COC. Means his claim is to be considered. That is the stage where you will apply my possession is I have the possession, but my execution of conveyance deed is pending.
No, actually, sir, my confusion is that where the registration is also done. Suppose the registration is also done, then also you say that only the
when the registration is done, it is inbuilt that you get the possession of that property. Then you have a right. You have a right to transfer.
In that case, also I cannot sell my property to other.
Why not? Why not? No, you have to go by the specific clauses mentioned in the conveyance deed. What right you exercise? Sometime the buyer builder, they have an inbuilt provision that the builder will always have a right to lease that property.
Okay.
Then you cannot sell it without his consent or without the consent of the lessee. So you have to read that clauses of the allotment letter as well as the conveyance deed also.
Okay.
Because the builders are there very smart. They will try to protect their own right. Even if you become the absolute owner of that property, they will try to hold the leasing right with them.
And my second question is then, earlier what's happening, the RP generally considered that 8% interest for the purpose of determining the voting right. Now I think it is changed. So how do you suggest to recast the claim statement once again? I mean,
let me put it this way. While verification of the claim, it is the principal amount which is identified, that you have deposited X amount of rupees in the corporate debtor.
Okay.
Now, all other incremental benefits, whether it is interest, assured return, or they are documented, they should form part in the BBA.
Yeah.
Now, as far as interest is concerned, I have come across a situation where one is allowed, as per the BBA, allowed 8%, 10%, 12%, 15%, 18%. What IBC has allowed is a uniform rate of 8%.
Yes.
But you will find number of document allowing that interest as well as the assured return also. Now that BBA is a basically contract act between the investor and the promoter.
Right.
You have to go according to that document.
Okay. Thank you, sir.
Right.
So, sir,
Thank
may
you,
I ask?
Second, who was asking the question, there is some question also in chat box. Can we read that? How do you deal with claims of home buyer who has been given possession of flats that has already been taken care of? Now there is
not
another
taken care
person.
of. There is one ambiguity in that. Now some
Okay.
IRP, they take the 100% claim, and someone are just acknowledging by 1 rupees. I could not understand that logic for the 1%. I'll request Mr. Makija to please clarify that. What is the logic behind accepting the claim at rupees 1 only? Just to make him say in the COC.
Makija sir, are you there?
No, I'm there, but I'm just trying to understand the question first. So what is the question?
Sir, the question is, someone has been handed over the physical possession.
Okay.
And as per BBA, basically obligation of the promoter is discharged the moment you hand over the possession.
Right.
Now, a claims comes before the RP stating that only execution of the conveyance deed is pending.
Right.
He is not mentioning his claim amount. In some cases, they mention the claim amount, saying possession is with me. Now, some RP, even I have acknowledged the total amount claimed by him as a financial claim. But over the last 1 year or so, I have also noticed some are accepting their claim at rupees 1. I could not get an answer from anyone. What is the logic behind accepting rupees 1? Because if he has to say something, then he must have the voting power based on the total claim. 1 rupees is not going to solve this problem.
See, typically, let us understand the problem. Number one, possession, which if it is handed over, definitely the person is not a claimant. It doesn't remain an allottee. But having said that, let's correct ourselves. In RERA, there are two things which are very important, and a person remains allottee till that time. First is possession. Second is register deed, registration. Both the things are very, very important. And till the time those two activities are done, the person is considered as an allottee.
Yes, sir.
Now, if the person is considered as an allottee, then in that event, if we go by section 5, subsection 8, clause number F and explanation, now the meaning of the allottee is to be taken from the RERA. Right?
Yes.
So typically speaking, he remains, an allottee. Now, I'm not suggesting that this should be done. I'm not defending, but my only answer to that, like you said, you were trying to find an answer.
Yes, sir.
So it could be that since he has been handed over possession, so he has zero claim because he paid the money, he got whatever he wanted to get, right? So therefore, there is no claim in a financial sense.
Right.
But since registration is not done, so typically he's a claimant or an allottee to that extent that he wants registration to be done because there is some work which is pending, right?
Yes, sir.
So therefore, probably the RPs are considering at rupee 1 so that as far as voting power is concerned, his voting is gone, but he's still considered as a allottee in the sense that registered deed is required, whether new RA comes or doesn't come, at least the flat should be registered in it. Probably this could be the purpose. That's my thinking.
Right. Thank you.
Sir, I
Any
have
other
a couple of
question?
questions. Sir, I have a couple of questions.
Yes.
Number one, in case a allottee or a plot buyer, whatever we call, or a home buyer, we call it, he has got
Yes.
only one pager provisional paper, which is not a proper allotment letter. Like
Okay.
if we have, say, if we have 1,000 members,
Yes.
everyone has got a detailed allotment letter, which is saying this is the consideration, this is the square feet, this is what is you are supposed to pay. But
Yes.
few may have a letter which says we have received X amount, although it is paid by check, against allotment of dash dash dash, but no consideration mentioned, nothing mentioned, it's just a single page. So how
See,
do we consider him?
that is a big problem. Basically, he no doubt, as you said, it is confirmed that he must have paid the amount to the corporator, maybe in the capacity as a financial creditor, as a financial unsecured
Possibly,
unsecured
because
loan.
the
Because
letter says that final allotment will be given to you. So that is how allotment letter.
just see who has signed that letter. Because all other if 99% are having a letter having a proper ID and on a particular maybe three, 4, or 10 pages having all the complete detail on that, I think that letter should not suffice to accept him as a allottee.
Okay, number one. Number two, now if the allotment has been issued and a bank
Yes.
loan has been taken, a tripartite agreement has been executed.
Yes.
The project is not complete. It is left by the developer halfway.
Yes.
Now, does the bank have any authority to sell it under SurfaceE? Because a lot of banks have done this.
It cannot be sold of late. I think it has been with the intervention of Supreme Court, and CLET has just recently admitted one claim. Yes, now the bank has a right to submit the claim in place of the allottee.
No, here what has happened is the bank has
that is
sold
the
to a
only
third party.
possibility. No, he cannot exercise any right to sell under SurfaceE once the case is admitted in IBC.
Okay, thank you.
Next question. Mr. Pradeep Chauhan, please unmute yourself.
Yes, I would request Mr. Makhija to throw some light on this provision vis-a-vis Section 53A of the Transfer of Property Act. I mean, if the possession is with the allottee, then Section 53A of the Transfer of Property Act comes into play. My question is whether the provision of Section 53A of the Transfer of Property Act would prevail over the RERA provision, or RERA provision which says that they will be treated as allottee will be superior. My question is over.
Makhija sir, question is to you, sir. Please clarify.
Yeah, sir, can you repeat your question? I've not really understood the question. Can you repeat that?
Sir, as per Transfer of Property Act, the Section 53A says when the buyer has fulfilled his promise, then he cannot be evicted and he is a deemed owner. Now, you quoted the provisions of RERA that till the registration is done in this particular case, apart from possession, till registration is done, he will be treated as allottee. I mean, he will be treated as financial creditor. So my question is how the interplay between RERA provision and Section 53A of the Transfer of Property Act would be solved.
Okay, see, let us understand 2-3 things. RERA is typically for the home buyers who have not become the property owners. Let's understand the objective of RERA. RERA was brought in with an objective to protect the home buyers, and therefore it typically said that, look, if you pay money, it should be kept in a separate escrow account, and those kind of things are there. So RERA purpose and the Section 53 of Transfer of Property Act, they typically serve distinct purposes. Now there is no direct connection. So Section 53 is when you're talking about that I'm in possession, I'm staying there. So therefore you are the owner of the property, isn't it? So once you are owner of the property, then it is a different thing. But at the end of the day, when you're talking about RERA, you have not become the owner. So that means you are simply an allotee. So RERA is typically come for delays or non-completion of projects. RERA authority can impose penalties, they can order refunds, or they can also even go for imprisonment of the developers. As far as the Section 53 TPA is concerned, now affected creditors who are there, then they can file a civil suit and to declare the fraudulent transfer as a void. So that is a separate issue altogether. I think we are mixing up two issues. Any follow-up questions, sir, then you have to tell me, because according to me, I'm very clear in my mind. RERA serves a different purpose. Transfer of Property Act is typically on a different footing altogether. It serves a distinct purpose. There's no connection between the two laws.
Yes.
Sir, one more
That's
question to
okay, sir.
Makhija.
The section was 53A, part performance. Anyway, I will keep on waiting for next discussion on this.
Sir,
Okay.
one humble question with Makhija ji. Sir, if there is a project where there are approximately 60 odd % registrations done, sale deed executed. Now,
Right.
how a resolution plan will be implemented, because the balance 40% will not be able to bear the cost, and anything approved by them is not binding on the registered plot buyers.
No, that is all right. But at the end of the day, the resolution applicant has to ultimately, what is the objective of a resolution plan in a real estate case? The ultimate objective is that you are going to provide the plots, I mean the flats to the home buyers. Now, if 40% have already been registered, so they are not
So
considered
this
as
is a
an
reverse. It's 60-70% is registered.
60-70%. So 30% are there. Now he will have to, whatever the balance amount is due, they will have to pay the money and then the flats have to be constructed. Now, having said that, assuming the money has been diverted and with that 30% flats cannot be constructed, right? The cost
Yes,
of
please.
construction is more. Now, what is the viability in a real estate plan? Real estate plans, the viability is that there is always an unsold inventory.
Yes.
People and those who are becoming RAs, they are not becoming RAs just to complete the construction of the existing building and hand it over to the existing allottees. Their revenue lies, they are eyeing what? The unsold inventory. So if there is an unsold inventory, I believe some of the RA will come, he will recoup that money from there itself. If there is no
Not there,
unsold,
sir.
if there is
No.
no unsold inventory, then there is a problem. Then no RA will come forward, according to me. So in that case, what I suggest is then all the home buyers who are left out 40% or 30%, they should form an association. They should actually submit the plan that we will construct ourselves. That should be a
If
Sir, but
better option.
again, if they will construct, if the registered will not pay, then they will not be able to construct, because the cost of construction will be 4 times then, because they are minimum lower in numbers.
Well, then they are in trouble, sir. I mean, nobody can help them, no. See, ultimately, at the end of the day, it is some RA has to come now. If he doesn't see viability in any project, he will not come forward. So now, what is the option left out? Option left out is, okay, I'll construct myself. But if the cost of construction is too high, then you see what can be done. Tell me, what is the
Is there
solution?
any way? Is there any way to bind the registered plot buyers or registered home buyers, flat
No,
buyers?
Why will they pay? They have already got. They have paid full. You see, if they have paid the full
No,
amount.
but they are still not able to occupy, because only structure is there. Even they can't live into that property.
So then, naturally, to make it livable, naturally, what are the common facilities there? They will be ready to pay. Have they paid 100% of their share? That's the question.
So they have got the sale deed registered. That means they have already paid.
They
I'm not
already
answering
paid.
the question. Sale deed is fine, sir. But the point is, they were supposed to pay X amount. Have they paid X or X minus Y? If they have paid full, then why they will pay extra then? That is the question.
Okay.
Okay. Anyhow.
Then
Sir,
Makhija sir, they will also
I have
pay,
a
no?
question,
Sharma
sir.
Because
ji, excuse me, please,
Ji.
one by one, we will ask the
Yes.
question. Mr. Dev, you want to ask some question?
I just wanted to add to what Makhija sir was saying. If their plot is not complete, or let's say even if they have got the registered one, then they will also pull and build like what was suggested. Otherwise, home buyers will consider, it's a haircut kind of thing, or increased price, and people who are left only they will have to take care of it. Like I'm handling a CIRP case where similar situation has happened. 60% already registered, 40 are left. Uh, Real estate cases are are always difficult. I just wanted to say there was no question here. I just
See,
wanted to
Okay.
I would like to answer this situation. See, all the registered holder, they are out of the CIRP and leftover is just 40%. Now, it is a question of if that building is not livable, then you have to, then all the registry holder, they are supposed to make the payment of the maintenance charges. Now, RWA, if RWA is managing that property, then they have a right to recover all the maintenance charges from the registry holder also. That is the
Sir,
only way out.
maintenance charges will not make the building, sir. It's only 2 rupee, 3
So,
rupee
building
per square
the left
foot.
of
So
those
that is only to survive.
so though left, they have to manage the resources. There is no other way out in IBC.
We all agree on that, sir. Yes,
Yes.
correct.
Sir, any other question? There is one question. If the books are not available and the promoters went in jail, how RP can collect the claim?
So based on the document submitted by along with the claim, he has no other option. He can or any document available in the public domain. That is the resources available to IRP or RP. He cannot go beyond that.
Sir,
I
if
think
registered
Mr.
flood
Sharma,
buyers,
no,
yes.
I'll just answer. Mr. Sharma has already dealt with these kind of cases. Now, where the books of accounts are not available, naturally he is right. You'll have to look at the documents submitted by the home buyers. So you can ask as many documents, including the proofs of the bank payments. So if they have made the bank payment, so naturally they can submit their bank statement that look, we have paid that. So basis this, I think there should not be any problem in admitting it.
Yes, sir.
Any other question? Shall
Yeah,
we proceed?
can I ask
Please.
a question? Hello?
Yes, yes, please.
Yeah,
It is an
actually,
interactive session. You can go ahead.
yeah,
Please.
I have a question to Makija sir. Sir, you just said that for that 60% registration done, 40% not done, so it is a problem for them to get the good applicant. But sir, what's happened, in a project where the maximum portion is constructed, everything done, only the facilities are pending, barring 2 towers. And in these 2 towers, there are some flats which are unclaimed. Even by giving the notices, connecting them, no claim has been filed. Can these flats be considered as inventory so that RA can be attracted?
Actually, sir,
No?
the point is if the claims have not been received, so you will wait up to a certain time. You will not wait for the infinity.
Right, sir.
Ultimately, the plan has to be approved. Once the plan is approved, no claims can be filed after that. There's a kind of a clean slate, which we know that principle is there. So typically, the SRA, I mean the resolution applicant, will eye these you see flats as unsold because no one is coming forward to claim. What happens is some of the resolution plans also contain a statement that those home buyers who have not filed the claim till the approval of the resolution plan can still approach the SRA that they have the flat, and then sometimes a differential treatment is given. That assuming they file the claim within 6 months of the approval of the resolution plan, then they probably have to pay 2,000 rupees per square feet extra, or 3,000 or 1,500. So generally, that clause is kept for the sake of the benefit of the people who have not claimed it, right? But if they do not claim in the next 6 months, then naturally they are bound by the resolution plan, and then he treats it as his inventory, as unsold inventory. So it depends upon how many persons are there. See, at the end of the day, let's understand who is a resolution applicant. Resolution applicant is jumping into the fray to make money, to make profits only. He's not there to give charity. What he will do, he will collect money from them, and he will not going to spend out of his own pocket to construct. So he's trying to make money out of it. So obviously he's eyeing the unsold flats. So unsold flats could include the people who have not claimed it, okay, who have not lodged the claim.
Yeah, but RA said that we have to take the legal, we have to find the legal possibility of taking cost injuries at the inventory or not.
No, there is no legal. No, there is no legal. See, at the end of the day, the flats were sold.
Vinisha.
This information will be available on information memorandum. RP will provide this information that total number of flats were 400, 350 were sold. Out of 350, claims have been received only in 250. Now
Yes,
it is
sir.
for the RA to look at his this project, whether it benefits him or not, then he will submit a plan. But if somebody does not file a claim and up to a certain limit, like up to the approval of the plan, or maybe after the plan also, if the plan says so, then of course it is an unsold inventory. He can use that inventory. So it all depends. I mean, we can't have a very thumb rule
Clear,
on
clear,
this.
clear. Okay, okay. Thank you.
Okay, Sharma ji, you may proceed.
If anyone
Hello.
has any other question, you're most welcome.
There are
Sir,
many
only one
questions in
question,
the
sir. One question.
chat box. Yes, yes, please, sir. Please.
Not in the chat box. I'm just asking directly. Suppose
Yes.
if the construction is going on and the RP has taken over under CIRP, and suppose somebody comes and wants to purchase a flat,
Yes.
can RP accept it?
No, RP cannot sell it. There's no
Because
authority
it
to
has to
sell it.
be.
Because it has to come, any sale can only take place only through the resolution plan. RP to make it a going
It's not a going concern.
Make it a going concern. If something is left over in the particular flat, or he can get it completed. But the unsold
flats cannot be
because
sold.
unsold flat is an asset of the corporate debtor. He has no right to sell that asset of the corporate debtor. He has to
Because
approve.
he is in charge of
If it is
corporate
during CIRP, then he has to take the consent of the COC.
Yes. Sir, there is a question, various questions in the chat box. I will be reading that. In case a buyer doesn't have a proper allotment letter, it is just a letter saying application for allotment without any consideration mentioned. Will it be
Yes.
taken as allotment letter?
No. It should be complete in all respects. Without consideration, that is not that cannot be accepted.
That has no legal standing in
Yes, no
anyhow.
Yes.
Whether the home buyers having possession of flat and got registered the UDS in favor is entitled to submit claim for basic amenities like STP, lift, etc. and be categorized as financial creditors in class.
See, I think this question has already been answered by even Dr. Makhija. The solution lies under the either resolution professional does these things to make it a going concern subject to availability of the resources, or this has to be shifted to the resolution under the resolution plan.
Sir, one question is there.
Yes.
There was some judgment on some bank can proceed and file claim in
Yes.
place of the allottees. Can you
Yes.
elaborate, sir, that
So
judgment?
I think specifically that relates to profile funding in some of the cases. And of late, Supreme Court, as I said earlier, with the intervention of Supreme Court, NCLAT has already allowed the banks to submit the claim, because someone should submit the claim. In profile funding, in some time, even the employee is not aware that a loan has been taken on his name. He's not aware of that.
Got it, sir. Got it. Now, sir, if registered plot buyers are out of balance sheet
Yes.
and there is a loan standing of mortgage
Yes.
of the entire property of the CD,
Yes.
so what will be the status of registered plot owners then?
If whosoever the registered holder, they are out of the CIRP, they become the independent, they are absolute owner of that property. So whosoever are the leftover, they have to take care of that.
A bank can independently proceed against them.
Bank, no, they has to approach. And yes, in case of profile funding or under a tri-party agreement.
Under a tripartite, no, not tripartite agreement, a mortgage deed between the company and the bank.
See, just tell me, what is the query?
Entire project is mortgaged with the bank. Simple,
Yes.
sir.
Yes.
A proportional funding is available.
See, bank can submit his financial claim, but not as a property owner. He can submit his financial claim, most welcome. He might be having 100% chance on that property.
Yes, yes.
But he is in the business of financing, not in the real estate or as a allottee. He has not purchased
Yes,
the space.
It can't proceed individually against the plot.
No question arises.
Wow. Thank you, sir. Thank you. You are so clear in your entire legal aspects. Now, any other questions for sir? Because some Mr. Sankaranjan has written some question. Can they ask?
Yeah, this is Pradeep here. I have a question. Can you
Yes,
guys hear me?
yes, yes.
Sir, I had booked two flats at Divya.
Two flats.
Hello? Hello?
Just repeat your question, please.
Yeah, I had two flats booked at Divya Infra Properties, and
Okay.
they've gone for insolvency.
Yes.
And this process was almost clear from last 15, 16 months. But suddenly, 2 months back, they said that one of the property, the builder has sold it to someone else.
Okay.
So I had a tri-party agreement. So now how can the builder sell it to someone else? I don't know. So I just trying to inquire what should be the next process from my end. So they accepted one claim of my wife's, and my claim
Okay.
they've rejected. My claim they've rejected. So what should I do, sir?
What I have understood is you have booked a flat in which the promoter has already sold to third
No,
party.
yes, sir. No, I have put two flats, one in my name and one in my wife's name.
Okay, that's fine. But you are saying your wife's claim has been approved and not yours.
Yes, they are accepted. They are accepted for the completion. They said that I need to pay them on 950 rupees per square feet, and they will hand it over the flat to me.
If your flat is in the same property which is not sold by the promoter, then you can again approach the RP. If he is not accepting your claim, then you can approach the NCLT.
No, sir. They say that out of the two flats, one the promoter has sold it to someone else. Though we have a tri-party agreement.
Okay, you mean second sale? No, again, you have to approach the NCLT for taking a decision on that. There may be.
I have approached. I have approached, but
you are a first allotee or the second allotee?
Yes, sir. I was the first. I was the first party, sir. I was the first one.
You are the first allotee. Then you have all the right on that property. You must approach the NCLT.
No, they are not responding.
Who is not
they
responding?
Are not responding for
who is
the Prakul, the guy IPR. I don't understand the terminologies. They are the guys who are working for the insolvency.
No, IP is not responding, or who is not responding?
IP is not responding.
See, once you have filed an application before the adjudicating authority, IP is supposed to file reply to that.
No, they said that they have sold it. After that, what should be my steps? I'm not clear.
Even if the builder has sold it, still he has to clear the facts, submit a reply before the NCLT. Look, this is the position. A has applied for this property on this date, made the payment, and B, whose name the registry has taken place, is the subsequent allotee. Then the option available may be in case of any alternate. In case any alternate property is available, that can be offered to you, or a case should be moved for cancellation of the registry done, because the second allotee has no right on that property. It is the first allotee under the Transfer of Property Act. He is to be considered as the allotee. Then the application for cancellation of the sale deed has to be moved.
So this can be moved at NCLT. This cancellation of registry.
Yes. Now NCLT is authorized to take that decision.
NCLT can cancel the registration.
Sir, I don't can you let me? What should I do, sir, now?
What was supposed to be done, you have already done. You have approached the NCLT. Now your advocate should plead for a cancellation of that sale deed.
I need to get another advocate for this.
No, the same
sir,
advocate.
That you can talk to Mr. Sharma later on, not in this group. Any queries we can address, sir?
Okay, but I need to approach NCLT, right?
Yes, you have done correctly. As Mr. Sharma said, you can approach NCLT. Now we'll move to next question. Mr. Srinivas.
Okay. Thank you, sir.
Thanks. So this will be the last question.
Can I approach that? In this case, can I approach RERA authorities for
No.
doing justice?
No, RERA is not involved. The moment it is in CIRP, all proceedings in RERA will stop as on signed die.
But here, owner has fraudulently transferred the title deeds to some other person. It
Yes.
triggers fraud and cheating also. Can I go to criminal courts? NCLT, it will take time, no, sir.
See, there is no choice. Once the CARP of an corporate debtor is admitted, initiated, then you have no option except to approach the NCLT.
Sir is saying NCLT is not responding, IP is not responding.
Sir, I will interrupt here.
So what?
Excuse me. May
What
I
are
interrupt?
what are else the
See, I cannot accept. I cannot accept this that NCLT is not responding. Neither I can accept that IP is not responding because he is bound by his statutory duties under Section 18 of the IBC. He cannot escape himself from not submitting the reply.
I do know, sir. IP should not reject anybody's claims.
I think
But
let
still,
me.
Sir, this
Okay,
is procedural things.
No, let me intervene. I think I've understood your question, sir. Let's understand in a broader fashion. Number one, you are supposed to file a claim with the IP. Whatever the facts are there, you have to convey it to them. So he is bound to either accept it or reject it. So it is his duty. So you must get a letter rather rejecting or whatever. So on that basis, you go to NCLT and approach it for admission of the. That is one part. That is only protecting your money, because if you don't file a claim, we were discussing just now that you may be excluded. So that will be a problem for you. Now, having said that, feel that your
అలా నేను ఏదో ఫోన్ చేస్తుంటే ఏదో చెప్తున్నాను, నాకు వినపడట్లా. 7, 8 అట్లా వస్తాడు అనుకుంటా నాకు తెలిసి.
Mr. Shyam, please mute yourself.
That your flat has been sold to someone else. Now, in that case, it is a case of a fraud also. So you are free to approach the police and file an FIR. Who is stopping you, sir? The criminal cases cannot be stopped. Now you go and do that. Nobody is stopping you, right? Okay.
So should we end this session now?
Thank you, sir.
Lot of knowledgeable interaction has gone. So now I will request IP Sumit to express gratitude on behalf of IPNet North and offer a memento to our speaker.
Sharma, so this will be.
Thank you very much. Makija sahab, I will collect the original from your office.
Yeah, thank you so much for your address.
Yes.
Thank you.
Sir.
Thank you, Sharma ji.
Thank you, sir.
Now I would request IP Sandeep Chitkara to introduce our second speaker, Ms. Pooja Bahari.
Yeah, yes, Pooja. So now IP Pooja Bahari, she has to her accreditation. She is the third women insolvency professional in India, but she has been actively handling cases under IBC since 2017. And she is an alumna and gold medalist from Shri Ram College of Commerce, Delhi University. She has extensive expertise in NPA resolution, insolvency, and liquidation, with over 22 years of experience in stressed asset management. So previously, as a consultant for banks, she has helped resolve cases worth approximately 11,000 crores under the SARFAESI Act. She has successfully managed 10 IBC cases, including during the COVID period. And currently, she handles some high-profile cases like United News of India case. She is renowned for her integrity and high ethical standards, and she has contributed to landmark jurisprudence in insolvency law. And she is a sought-after faculty member for IBBI, IPAs, and various government and educational institutions. Over to IP Pooja Bahari.
Very much, sir. Thank you so much for the kind introduction. And before I start the session, I just want to share my presentation, and I would request you all to please confirm whether you can see it full screen. Is it visible?
No.
No.
It is in process, I believe.
It is in
Can I,
interest of
No, not visible.
it isn't?
No.
so
I
message
will
is
share
there
again,
that
just a second.
message is there that this has started screen sharing.
Hmm.
It's visible now?
No,
Mhm.
your bandwidth is low. That's appearing
Yeah, actually,
on
my
your.
bandwidth is a bit low. So,
Okay. Can you
is
share
it
with
all
me?
right?
I
Then
can.
I guess
No,
uh,
not visible.
yes.
Can you share with me?
No,
I will try to share on screen.
just a second,
Hmm.
please. Yeah, but then I would just a or if it is all right, I will let me just maybe just discuss the presentation if it is all right, because we only have about I think maybe half an
Yes,
hour,
yes,
like
please.
45 minutes.
Go ahead as per your
Yes.
wish. No
So
issues.
yes,
But you are
yes,
also not
right.
visible.
So now fact of the matter is, I'm not visible also. Just a second. Okay. Am I visible now?
Yes.
Yes.
Okay. Right. So what I'll do is primarily we are going to be discussing fraudulent transactions today. As you know, avoidance is a very important subject. And in fact, there is a lot of jurisprudence which has formed. A lot of it has reached finality, but a lot of part of it has also still not reached, finality with primarily with fraudulent transactions. I think as an RP, it becomes extremely important for us because there are two, very important regulations and sections which are there because of being, we need to ensure that any avoidance transaction, any fraudulent transaction is properly catered to. Whether, the regulation 35A, which says by the 75th day we form an opinion, or wherein we need to make a determination, or where we need to file a copy of the application before the adjudicating authority by the 115th day. So it becomes very important for us to, ensure that we are following all the regulations. And now, then recently, the amendment which had been made is now even RP has to forward a copy of the application to the prospective resolution applicant, enable him to consider the same. So it becomes extremely important for us to understand the fraudulent or the avoidance transactions. And in fact, even the regulation 39 says that whenever we are actually, placing a resolution plan before the committee of creditors, we have to, along with that, include the details of the transactions of preferential, undervalued, extortionate credit, or fraudulent transaction. So this is in CIRP. Again, in liquidation, I think as a liquidator, it is our duty to investigate whether there are any avoidance transactions, fraudulent transactions, and in fact, if any amount is recovered through proceedings of this avoidance, as per Section 36F, it becomes a part of the liquidation estate. So that is why it becomes extremely important for us to know about these particular transactions and how important they are, from the point of view of actually that, as an RP, as a liquidator, we are, it becomes very important for us to ensure that we are catering to the proper, ensuring that we are able to determine the transactions, we are able to make an opinion on the transactions. So that becomes very important. And now the regulations which have now been added also, that when a resolution plan is approved, the manner in which these avoidance, fraudulent transactions, how they will be pursued after approval of the plan, and the manner in which these proceedings will be proceeds from these proceedings will be distributed also in that aspect. And again, in liquidation also now we have to take the advice of the liquidator that how a proceeding in respect of an avoidance will be pursued even after dissolution or after closure, and the manner in which the proceeding of these proceedings will be viewed. So that's why it becomes extremely important for us to understand the avoidance transactions, for us to understand the what is about the fraudulent transactions also. So primarily primarily, there are transactions which can be avoided, of course, when you're, making a bet to someone to put the recipient in a more beneficial position, or, if there's a transaction which is, if an extortionate credit transaction where you're, taking a debt on exorbitant terms. But what is most important, what we are considering today, we are not doing, the preferential transactions or the extortion, but in with reference to fraud transactions, they become very important.
I think Pooja has connectivity issues.
Hi, could you hear my presentation? Ma'am Tina?
No, Pooja, you have connectivity issues. We are not able to see you even. And there is
So,
some
but could you
standstill
hear,
also.
could you hear?
No, in
Okay,
between the voice
so
also went.
okay, so I will
Can you log in
again
from another
restart.
system?
I think I hope.
Can you log in from another
Let me just
system
try and log in.
or from mobile?
Can you hear me now? No, can you hear me now?
Yes.
Okay, can you hear me now? Primarily, okay. So basically, as a RP or as as a liquidator, it becomes extremely important. Can you hear me properly now?
Yes,
Yes.
you are
If you could
visible.
share the presentation, we will show
Yes,
them.
right.
Hannah, please share with me. I will show them.
Okay.
Or share in group, please.
Just
And then you may proceed so we
just
can
a
relate
second.
also.
Right, perfectly. Just give me a second. Okay, so I'll speak in the meantime. I have already sent the presentation.
Yeah, you may continue speaking. We will do the
Yes,
needful.
right.
Please,
So
don't stop
primarily,
in between.
as an RP, it becomes extremely important for us. When we are at the 75th day, you have to form an opinion, you have to make a determination. You also have to ensure that you're filing an application 130th day. It has now also been added that the RP has to forward a copy of the application to the prospective resolution applicant to consider the same while submitting a plan. So whenever we are considering to ensure that that we are that whether it's avoidance transaction or a fraudulent transaction, it becomes very important because there's another regulation 39.2 that you can also only place those presentations, whether it's a preferential, undervalued, or extortionate transaction. You have to, whenever you're giving a resolution plan which needs to be approved. So the avoidance application also will have to be will also have to be, placed before the committee of creditors. As a liquidator, it becomes extremely important for you also to ensure that you are investigating whether there are any fraudulent, undervalued, or preferential transactions now. And if there is, any amount which actually comes in from an avoidance or a fraudulent transaction, it becomes a part of your liquidation estate. So making sure that, any transaction, any fraudulent transaction, any money coming in is a part of a liquidation estate. Also, these are regulations which have come in. There's a regulation 39.2D, where a resolution plan has to provide the manner in which the proceedings of avoidance, how they will be pursued after approval of the plan, the manner in which the proceeds from these proceedings shall be distributed. So it's very, very important that we, deal with the fraudulent transactions. We know all the rules, the regulations with reference to avoidance and fraudulent. I will be covering a lot of challenges in this next half an hour. And also as a liquidator, now, as you know, there are two regulations, which was 38.2D, which had been added, where the plan has to see the manner in which these proceedings of avoidance will be pursued after of the plan. And in liquidation, Regulation 44A had been added, that how on the advice of this stakeholders consultation committee, you have to, even when you're filing an application for dissolution, so how these proceedings, these fraudulent proceedings, how they will be pursued after dissolution or closure of the liquidation process, and the manner in which the proceeds from these proceedings will be distributed. That's why it becomes extremely important for us to understand the fraudulent transaction. And yes, there are, there would be a preferential transaction, where the transaction has the effect of making that person in a more beneficial position than it would have been in the case of, distribution of assets. Or there could be undervalued transactions, which is, implies an unequal exchange, or maybe it's not an arm's length transaction, or a transaction which is creditor. So, the section 49 says that if there is any undervalued transaction which has been deliberately entered by the company to keep the assets of that company beyond the reach to adversely affect the interests of that person, that also, you can make an application to the NCLT to restore that position, to protect the interests of those persons. I hope, Ma'am Tina, you've received my presentation.
Yes, it is now being shared. I hope everybody is able to see it.
Yeah, it is. Yes. Okay. So basically, besides the, extortionate credit transaction, the most important what we are discussing today is we'll be discussing the section 66(1), where, where the business of the corporate debtor, if it has been carried out with an intent to defraud the creditors, then anyone who is knowingly a party to that shall be liable to make such contribution to the assets of the corporate debtor. So this is section 66(1). Or even section 66(2), where a person who knew or ought to have known that there was no prospect of avoiding the commencement of CIRP and that director did not exercise due diligence, then you can file an application to direct such director to make the contribution to
I think Ms. Pooja Behri has some connectivity issues. Ashish Makhija, sir, can we proceed with question answer session instead?
Yeah, I'm sorry. Can you see the presentation now? Can you come to the
Pooja,
issues
can
and
we
challenges
proceed with
in
question
fraudulent?
answer session? Can we proceed with question answer session? As your audibility and
can't see the-
connectivity is poor.
No, Tina, just hang on. Since Pooja is there, we can hear her now. Let us let her complete on this. Yeah, Pooja, please go on.
Yeah, okay. So primarily what I need to discuss with you is with reference to issues. Can you hear me, the issues with reference to what? That is all right? Can you hear me now?
Yes, please.
Yes, that will be good.
Yeah. So the issues with reference to avoidance are primarily that, there are cases where, the investigations are ongoing for a long period of time, where dissolutions are pending due to pendency of investigations. And of course, in one of my matters, only the order had been passed that when I had filed an application for fraud, then yes, of course, the court said, yes, there is a fraud. There is, too much documents which are available. But even when the entire is done by the RPs, then there are cases where the court has ordered that if there is any pending investigation, then that company cannot be dissolved. So what is happening that in this particular matter, years after I have already done the distribution, I still able to dissolve the corporate debtor because the court has ordered that the dissolution will to the legal existence of that company. So accordingly, what has happened is lot of cases where there are pending investigations, the liquidations continue for a long period of time. So what is needed is a clarity in the code that when investigations take many years, then how would that liquidation conclude? Who would bear the expenses? What fees would be payable? So this is one aspect of a fraudulent transaction which is there, which needs to be, primarily looked into. Then another aspect which needs to look into is, yes, there is, the regulation says, there are challenges where, with reference to, there is a regulation 44A, which says that, treatment of avoidance, how it will be done in liquidation. And of course, the similar regulation 38 is therein for resolution. But what happens when the resolution applicant is actually not interested to pursue that particular avoidance transaction or that fraudulent transaction? So yes, I think there's an advice which needs to be given that yes, maybe certain, like SFIO, CBI, ED, maybe those actions may be dealt with by some specialized agency. That is extremely important because
Please take questions if possible.
Sandeep ji, can you take over? What happened actually?
I think there is some connectivity issues with Miss Pooja. So
yeah, can you hear me? Ma'am, can you hear me?
No, ma'am.
yes,
Okay.
we can
Then there
hear
are
you
cases.
now.
Okay. Okay, then there are cases wherein the applications which are actually for fraud being filed, which are taking months, and there are a backlog of applications, and there are a lot of contradictory judgments which have been passed. So there was in a fraudulent rapture recently, it was the matter with justice, not motive. A lot of liquidators, when fraudulent applicants are made, they do try to say that, assign them as not readily realizable asset.
Cannot hear
But in
anything.
actuality, the NCL, I'm very sorry, actually, I have a
Ma'am,
network
can we
here
take
and
another
it
date
is
how we
not
do it
getting
in
resolved.
NCLTs?
Yes.
When it is not possible, we normally take dates, next date. So can you please allow that? Because it's not making any sense, I guess. It's wasting time now. So,
Makhija sir, can we take up question answers because our audibility is very
Please,
poor,
please
Pooja.
apologies.
If you can
Yes,
connect with mobile
apologies.
and answer
Actually, I have.
questions, Pooja,
Okay, I'll do that. Yeah, I'll do that.
that will be much better.
Okay, I'm
actually,
actually
for
apologies.
session.
Like, electricity never goes in Delhi, but electricity went off today. And so that's why I'm having an issue connecting with my phone only. That's the only issue.
Okay. So audience may drop their questions in chat box and can also ask virtually once she also appears, Pooja, to mobile.
I think you can, Tina, you can have a general discussion. Anyone who wants
Yes.
to ask a question. So let's do that. Let's not.
Let's start with that.
Yeah,
Yes,
let's do
sir.
that.
Sure. Any questions anyone wants to ask? I think Mr. Sharma is also here. Sharma ji, you are also here? N.K. Sharma, sir? Okay, audience may ask the question. We'll call the relevant person.
So may I ask?
Yes, yes.
So okay, thing is that it is expected that the resolution plan should carry actually some kind of reference to basically the profit transaction proceeds. So how those proceeds will be shared, or maybe how those proceeds will be entertained as part of the resolution plan. So the thing is that let us say if there are no arguments happening, or the arguments are yet to happen in the case of a section 6 application, those are yet to be initiated, then in that very case, how come the resolution plans will actually mention about the proceeds of the avoidance or profit transactions? So how this is to be taken care of by the PRAs?
Can you please repeat, Sandeep ji? Sharma ji is also here. Can you please repeat once again?
So
In short.
this is regarding fraudulent transactions. So thing is that resolution plans are supposed to actually take care of the proceeds from the profit transactions. In case if in case actually an application is profit application is filed, or avoidance transaction application is filed, but in that very case application is filed, but arguments are yet to happen, as there have been lot many adjournments on that very application, but arguments are yet to be initiated. But yes, one application is filed and it mentions about certain transactions, certain amount of that very basically section 66 amount, which is already there in the application. And how come if the arguments are not there, if any kind of finality is not there, so how PRAs are to take care of this very thing, or the proceeds of the profit transactions in the resolution plan? So that is the question.
You want me to answer?
Yes, sir.
Yes.
See, I think while preparing the resolution plan, or the RFRP, or all related documents, it is made clear PRA is supposed to take care of that profit transaction on his own, or he want that the financial creditors want to take up that matter. In case he takes that responsibility to follow the avoidance application, he will clearly say, okay, I will charge 10-15% of the managing costs. Otherwise, all the proceeds will be shared with the financial creditors. So, and resolution plan, it is not, this application is not going to affect the resolution plan. Resolution plan will go as it is. It can, the avoidance application can go parallelly with the resolution plan.
So the thing is that there is no argument regarding this very application, and there is no clarity about how the things will go. And let us say if the PRA doesn't mention anything about the proceeds of the profit transactions, so how
question is, let me tell you practical experience. I have filed an avoidance application of say around 100 crores recovery from the promoters.
Okay.
Now yes. I have mentioned that in that form part of the IM, because you have to give the legal update along in the IM. What is the legal status of the corporate debtor? Now it is up to the now while preparing that जो numbering मेरे को नाम नहीं याद आ रहा है, तो we will mention in that in case the PRA take care of that, we will give him 4.5.6 point. In case he does not take care of it, then he will get the nil marks rating. So he will make you understand that he is going to follow that avoidance application or not. If he's following, he will definitely come out with a proposal that I'm going to charge 10%, 15% of the on account of my legal fees, and remaining whatever will be the proceeds, he will share it with the financial creditor. Otherwise, he will clearly mention that I'm not going to take care of it. Let the COC take care of that.
Okay.
Sir, this is in real estate case. If there are dual registries and some POFE application is filed for cancellation of the registry, and PRA says, I will carry forward this petition further. Now, if he doesn't pursue that petition, for example, he doesn't manages that, nobody pleads in that case, no outcome comes, and suppose XYZ is a person on whose plot there is a second registry of EFG, and that is to be cancelled. Now XYZ is the person whose interest is getting affected. So what will be
See,
the situation then?
application avoidance application in this matter would be that the business to defraud the creditors was going on, where one shop is sold to more than one person, and when the first allottee is eligible and it is registered in the name of the second allottee, then there is a case of business fraudulent business only. This is not a case where the defraud with the corporate debtor. Corporate debtor must have received twice the amount eligible against one shop. It is to defraud the creditors. Avoidance application will be that. And keep in mind, no amount is going to come back. It is the cancellation of the registry only. The rights may be given to the first allottee only.
I will throw some light on this. Second
Madam,
registry.
Yeah.
Yes, ma'am. Second registry.
Yes, I
No
would like to
amount
say,
of-
yes.
Madam, can we
Ma'am,
complete?
all I'd like to say one thing, I'll also like to add. Yes, please.
No amount has been received from the second registry. Allotee has paid the amount.
Yes.
So this is a clear-cut case of fraud with the creditors.
This is not a clear case with the fraud. This is clear case against the corporate debtor also. In this case, asset of the corporate debtor is sold to a third party without any consideration.
Two parties. One for consideration as an allotee and second,
yes,
without consideration.
Without consideration.
So if the applicant doesn't pursue it further, I as a first allotee, what does right I have?
Then I think Dr. Makhija already suggested no one can stop you filing a FIR with the police authorities. File an application, then you will get the success.
And Madam, I'd also like to add one thing. I think as an RP, we have our duty to ensure that if there is any fraud comes to our knowledge, that application will need to be filed with the NCLT. So it is the jurisdiction of the NCLT, what orders they pass. So if as an RP, you know that, yes, this is the kind of fraud which has been committed, you will file an application under Section 66, where you ask the directors to contribute, to basically maybe to make good to that third person or to get back the assets. But it is a fraud which has come to your knowledge. So as your duty, you will have to file that application. What may or may not happen in that application is, it may take years, they may appeal, then that appeals may go further. But as an RP, it is your duty to file it. And
you are right.
Of course, if you do feel that there is some kind of information will be given incorrectly to you as an RP or liquidator, you have these sections which are 68, 70, 71, 72, where that maybe they have not given you complete information, they have sold an asset maybe twice, and then the documents which are provided to you are incorrect. So you as an RP can also criminal complaint with the IBBI, and if IBBI feels that yes, there is fraud, or if those sections are applicable for penalties and offences, they themselves will again file a further criminal application. So this is as per my understanding, and of course everyone themselves who have been fraudulently affected by that fraud will of course file their
Next question. Sir, as an RP, what is our duties in respect of fraudulent transactions? What you have personally experienced, Mr. Sharma, real practical difficulties. Like in one of the cases, I will not mention, I have witnessed in NCLT that the liquidator is withdrawing the fraud application filed by RP because it was filed without any basis. So have you witnessed any such cases, or what precautions we as an RP should take? Because ultimately the onus is on RP. Then RP should verify all the evidence and supporting should be there as an attachment.
See, filing any avoidance application, there has to be a ground for that. There should be siphoning of the funds, or fraudulent transactions have taken place, fraudulent business has taken place. Unless you prove that, how can you file an avoidance application? It is not an application where you, for the sake of filing an avoidance application, you RP must file that. No. First, you have to, in some of the cases, like a practical difficulty, in transaction audit report, you will find somewhere that IRP or RP has not given us the complete document. Now, IRP, whatever document he is having in his possession, he is handing over to the transaction auditor. And if the transaction auditor in his report says he has not, RP has not shared, then that transaction report has no meaning on that. Because that is the transaction report is an evidence for any fraudulent transaction. So we have to be very careful even when we go through the transaction audit report. We must have some ground. Transaction report is one of the principal document based on which we will file the avoidance application. Yes, Tina.
Okay.
Yes,
Can I
Mr.
add one thing? Yes,
Yes.
ma'am,
Yes,
can you hear
Pooja.
me? Can I add one thing?
Yes,
Yes,
now.
madam, one thing is also important, that there are many directors who are not providing the correct information, and when on the basis of which we have our duty to determine on the basis of the documents which we have. Unfortunately, many times directors do not provide, and then there is a disclaimer in the transaction audit report, and that is something that's a continued disclaimer, which when we file an application, that this is on the basis of the documents provided to us. So there are cases where documents are actually provided at a much delayed stage, that when you actually file that application, I've had cases where instead of filing a reply to that application, they send me the documents after the application has been filed. And then also becomes an issue, because at that point of time, as an RP, you do not have the powers to relook your transaction audit or to relook your avoidance which you've already filed. So this is a practical problem which is now happening, that because of that, then that avoidance will get dismissed because you do not have the information. Now, I have a case where I'm handling where the data given to me is of March 2020. And everything has been sold thereafter. And I can see the kind of avoidance which has taken place. But I am helpless, because if you have 4-year-old data, there will obviously be a disclaimer in your transaction report. And that transaction audit, that disclaimer will be misused at a further stage, saying that this is not a complete report. So we also as an RP have our limitations, but I think we need to ensure that we are apprising the court of all the limitations of the issues which you have. You're making it sure that as an RP, I make it a point to write in all my minutes that this information was not available with me, and my report is basis of and there are sometimes deliberate attempts not to provide the information, so that avoidance is dismissed at a later stage. So it is that, but
Ms. Srishti has some question.
Yes, ma'am, I'm asking from the liquidator point of view. In 25J, section 25J, it talks about avoidance application to be filed by RP. But when we see section 35L, which talks about preferential and undervalued transaction only, that is duties of liquidator. So in one of my case, there's RP filed PUFE application. Then he withdraw that application during the CIRP. Now the company is in liquidation and no any PUFE transaction filed against the erstwhile directors before the NCLT. So liquidator is planning to file the application before the NCLT, but during that look back period, that is 2 year and 1 year, there is no such transaction because company is shut down before 2021. So, as mentioned in section 35L, the RP is to file the application for preferential and undervalued transaction. In that case, what our responsibility as liquidator for PUFE transaction? Because there is also filed section 19.2 application, directors are not cooperating, and we don't have any information.
Yes, sir. Sharma, sir.
Okay. Whatever action you take, that is based on the information available with you. Madam Pooja Berry is rightly clarified now. Put a disclaimer. See, you cannot produce the documents or information on your own. Maximum, what can you do? You can file an application under 19.2 that you not received this information. Now, CIRP or liquidation process cannot stop that you do not have the information. Then you have to proceed further based on the information available to you. And that becomes a benchmark.
Sir, we have some data that the company, the erstwhile management was involved in some fraudulent transaction. But
Yes.
when we look 35L, there is written that to investigate the financial affair of the corporate debtors to determine undervalue or preferential transaction. That is, as a
Yes.
liquidator, my duty is only undervalue or preferential transaction, or I can file the fraudulent application also, which
See,
as
you will proceed further. Only you have that report of the transaction auditor before you. On your own, you cannot.
Okay. Okay.
See,
Thank
on
you,
your
sir.
own maximum, what you can do if any
no.
if any fraudulent transaction comes in the notice of RP, that one property, one asset has been space has been sold to more than one. That is a prima facie document available before the RP. Based on that, he can proceed under section 66 whether for that the business of the corporate debtor was carried on with to defraud the creditors.
Okay.
Yes.
In
Sir,
that
I
case,
can, ma'am, I can add one thing also. Yes.
in that case, there is no need to wait for the transaction audit report because that is a prima facie document available before you.
Okay,
Yes.
sir.
I would like to add if there are cases, I would like to add one thing. If there are cases where fraud is automatically laid out, because there was one of my first matters, I did not get an audit done because the fraud was extremely apparent. There were fake invoices, there were fraudulent movement of goods, there were people, the tax departments writing to me that they have done, invoicing without actual without the actual physical movement of goods, and then they had given their statements sometimes that we have inflated the stock statement. So fraud was very apparent at that point of time. So when there are cases, in bigger cases, you definitely require an audit report. When there are multiple transactions, there are transactions which are it's a large scale company, but you can also otherwise also have a look at the book. If you are unable to see that if there isn't any avoidance transaction, then also you can give a report that there is no avoidance transaction, as long as you.
So I would ask Mr. Sharma, sir, if you have experienced yourself in some of the
Yes.
situations when you have filed an application, and what challenges you have faced as an RP, because how concrete the application should be for fraud and other things, because onus is all on RP. We are only called to tell how fit it is for fraud or other things.
See, I would like to share my experience. Indra from Habitat Center. One of the big four was appointed as a transaction auditor. Whatever document I was having in my possession, I have handed over to them. When the first transaction report draft came to me, I noticed prima facie they have written that RP has not handed over all the documents to us. I said, I have just wasted the fees paid to you. Nothing more than that. This is just a piece of paper before me. This report will not stand as an evidence in any of the court, because you yourself are saying that IRP has not given the documents to you. Then what report you have prepared?
Correct.
I said, whatever document I have in my possession, I have handed over to you, and I haven't received acknowledgement for the same. I do not have any other document. Now, as a transaction auditor, you have to apply your mind. You have to go to the public domain, whatever information is available, you are supposed to obtain that and prepare your document. You should write, IRP has given us an undertaking that whatever document he is having in the possession, he has handed over to us. Otherwise, what your report matters to me? Then they have corrected their statement, their report accordingly. Otherwise, it was just the wastage of money paid to them.
True. Sir, what should be the concrete evidences? Like, for example, if as you have come across so many cases, and even in real estate, there are so many frauds happening.
Yes, one practical example I will say. That was a commercial space on a particular given date. One shop is sold at the rate of rupees 13,000 per square feet. Another shop at the rate of rupees 10,000 per square feet. 20 shops were sold at the rate of rupees 7,000 per square feet. It was reported in the transaction audit report that, look, on a particular given date, these transaction has taken place. Now coming to the practical part of it, when I written to the person who has bought, say, 20 shops at the rate of 7,000, he said, look, it is a business transaction. We sat across the table with the promoter. He was in the need of money. I want to purchase I was looking for the space. It is my negotiating skills that I purchased 20 shops at the rate of rupees 7,000. When the buyer and seller both agree, who is having the problem in that? That was the answer given to me. And that auditor accepted that. Selling 20 shops in one go, not practically possible. And one shop, the promoter has all the right to command the way he wants. But if he is in the need of money as a business exigency, he can always negotiate with the buyers. This was one of the practical problem or situation which I have faced. Now all other present can comment on that, whether it was a business transaction or a fraudulent transaction.
Sir, prima facie, what I can say, it is not a business, it is a fraudulent transaction, because there are the guideline rates are there, all the things are there, market factors are there.
Let me tell you that 7,000, what is saying?
Is he related party, sir?
Circle rate, not related party, third party, independent. It was a normal business transaction. Selling 20 shops in 1 hour is not a small issue. Anyway, the transaction auditor, they accepted the reply given and was avoided from the transaction audit report.
So it was during 2 years, 3 years prior to the
Yes, it was.
CRP?
No, it not question ke 2 years. We have given them a period of 5 years. See, 2 years. I think the regulator should think about that. Sometime, even in initiation or admission of the case in a real estate matter took more than 2 years. Once an application is filed in the NCLT, you won't find any transaction, the corporate data, what are you going to do with that within that 2 years? That is a very valid query. In one of my case, the case was admitted after 4 years of filing an application under Section 7. So what period should I take into consideration for the transaction audit?
Agree,
It,
agree,
it should
completely
it should
agree.
be at least 2 years prior to the date of filing an application under Section 7. Because
Correct.
in that intervening period, there is no transaction. Now, what is the purpose of getting the transaction audit done? This is a practical problem.
Correct, sir, correct. There is a question in the chat box for you.
Yes.
Fraudulent transaction can be proceeded under Section 66 by liquidator without any look-back period time limit.
Yes. For fraudulent transaction, there is no look back period, provided you have the evidence that this transaction has taken place 10 years back.
And
For
consent of
fraud, there is no look back period. Only thing is that you must have the sufficient documentary evidence to prove that yes, this fraud has taken place 10 years back.
Sir, in
Any
that
other
case, in
question?
this situation, was the promoter foreseeing that the company will go into CRP?
I'm not getting.
That 20 shop case you are asking, na, sir? Ravi Shankar, sir?
Right, madam.
Yes,
So
that was my intent also of asking how many period prior to the CRP has done so. Was he has really done to infuse the liquidity or just he was running
was he
away?
foreseeing if
Correct,
this?
sir?
Right.
Yes. Sir, Sharma, sir.
I have not understood the question. Please repeat.
Sir, actually, what he wants to say, like if
Yes.
I'm a business person, I have to run the unit. I may
Yes.
sell in haste in need of fund.
Yes.
If what your auditor has accepted.
Yes.
He has accepted the money because he was in need of fund and he wanted to sell that much of commercial premises within a specified time.
That's right.
So his question was also that it was a general, genuine need of fund, or was he aware that the company is going into CRP? So let us get rid of everything and run away.
See, that is possible to for if he is having a day-to-day cash flow statements, which is next to impossible. When in a going concern, when the builder starts his activities, he only knows what is he going to do with that. His first thing, he want to sell the whatever 80%, 90% inventory available to him. And rate he will accept according to his own record. Because at that stage, though there is no regulatory authority on his head, he has to take independent business decisions. No one can question him at that stage. It is only in CIRP. Suppose he complete the project, who is going to ask him, why did you sell that shop at the rate of 7,000 rupees? We are questioning today, reason being he has failed to deliver the goods. Be practical, be practical. He has all the right to sell at a discount, provided he is selling a substantial portion of that. Yes, it could have, there could have been a problem if he is selling one shop at 7,000 rupees, other he is selling at 13,000 rupees, then definitely that is a fraudulent transaction, undervalued transaction.
Correct, sir. Agree. Because we too don't have any evidence also.
Don't have any evidence. Whether he was in need of money at that, the builder is always in the need of money. See, I can tell you with my experience, builder has no specific set of the documents. He'll say, you want to invest? Okay, come. What rate you will give me? You bring the documents, print yourself, and I will just sign it. You give the money. He will not look at. He's giving. That a document contains 12%, 15%, 18% interest or assured return. He knows that time also. He's not going to return it. That is why his interest is, his mindset is, accept the money which is inflow. Outflow will be at a later stage, which he is not going to honor it.
Correct.
So,
sir, one question related to this, as in one of our case, in real estate, we have found that during the look back period, OC is converted into FC class.
Yes.
FC class. So, as per section 43, we are giving preference treatment under section 53 to because from F clause F, they are coming to clause C, they are becoming the financial creditor. So is this fall under preferential transaction? The corporate debtor, the erstwhile director of corporate debtor, is arguing that we are doing this in ordinary course of business. They are our genuine OC. So is this fall under preferential or not?
This is what document he executed for making for making an operational creditor as a financial creditor in a class. Has he given him all the first he has to admit his liability. Yes, I admit this much amount is payable to operational creditor. And then if he, in case he is executing all the documents which he has executed with all the allottees, it is well within his right to do that. In my opinion, that is not a preferential transaction. He cannot advertise that, look, all the operational creditors come, I'll make you financial creditors. Those who have approached him, those who have discussed across the table, he as a promoter has all the right to make him a allottee, provided he execute all the document and admitted the liability.
But there are certain debts in respect of that OC, like 50 lakhs, and the CD has provided a flat compensating that amount. So they are giving preferential treatment under section 53 of that waterfall mechanism. They are
in my opinion, look the document he has executed at that stage. When he has made an operational, he is not an operational creditor on that date, because operational creditor is a stage defined in IBC. It is not in the accounting standard otherwise. Otherwise, he is a supplier, he may be service provider. That is an amount payable by the corporate debtor to one particular supplier. He has entered into a transaction prior to initiation of the CIRP.
Okay.
So just look at the document which he has executed. I have come across such situation, and Honorable Tribunal has relied upon the documents which he executed at that stage.
Yes, sir. Thank you.
Thank you. Thank you so much, all the participants, and thank you, N.K. Sharma, sir. Thank you, Pooja Bahari.
Thank you all for giving me this chance.
Thank you, sir. Now I invite IP Namrata to make announcement of next webinar.
Ma'am, I'm really apologies. I had an outage in my area and nothing is working. So extremely sorry for the bad network. Really very sorry.
No problem, ma'am. We understand. IP Namrata?
Yes, Meena ma'am. The next announcement is for 8th of March at 4 p.m., where we have the topic of IPA oversight, grievance redressal, and disciplinary process at IPA. The chief guest is none other than Mr. G. Narsimha Prasad, the MD, IPA ICMA, and the lead will be by the presentation by IPA ICMA team itself. We look forward to all of you on Women's Day, 8th of March.
Thank you very much.
Thank you, Namrata. Now I would request IP Sandeep to offer certificate of appreciation to IP Pooja Bahari.
1 second.
Yes, now it is visible. Thank you, Pooja Bahari.
Yes, thank you very much. Thank you very much.
Okay, thank you, Pooja.
Now I would request IP Vivek Chirania ji to offer vote of thanks.
Thank you, Tina. Good evening, everyone. It's a privilege to extend the vote of thanks today. I would like to express my sincere gratitude to IPNet for providing me with this opportunity. Today's event was much more than a webinar. It felt like the start of something truly significant, a movement that will shape our professional community in the years ahead. First and foremost, I extend my heartfelt thanks to both the speakers, Mr. Narendra Kumar Sharma and Mrs. Pooja Bahari. Your presence has added immense value to this occasion. Your insightful words and vision have inspired all of us to think bigger and strive for excellence. Thank you for gracing us with your time and wisdom. I would also like to thank our President, Mr. Ashish Makhija, Ashish sir, your relentless dedication and visionary leadership continue to make IPNet a platform of unparalleled importance. Your address today reaffirmed that we are on the right path under your stewardship. Your guidance gives us the confidence to reach new heights, and for that we are truly grateful. A special note of thanks goes to our keynote speaker, Araventhan SE, and our dedicated coordinator, Ms. Tina. Your valuable insights and perspectives have enriched today's discussion, offering us new directions and understanding that will surely shape our future work. Thank you for your commitment and for sharing your vast knowledge with us. I would also like to extend my sincere appreciation to Transition and the technical support teams. You work tirelessly behind the scenes, ensuring that everything runs smoothly. Your hard work is the foundation of successful events like this one. Thank you for your unwavering support and flawless execution. Finally, to everyone who participated today, your presence, enthusiasm, and active engagement have made this event truly remarkable. Together, we are building a community that will not only foster professional growth, but also drive innovation and collaboration in the insolvency profession across India. Thank you once again to all those who contributed, participated, and supported this remarkable initiative. This is only the beginning, and I look forward to what we will achieve together in the future. Thank you.